Hello, doctor. Hello, Selvaji. How are you, sir?
I'm fine, sir. I'm fine, sir. How are you, sir?
I'm good. I'm good. I'm good. Good to see you.
Okay, sir. Good to see you, sir.
Thank you, Dada, for reminding.
My pleasure, my pleasure.
Sir,
I think we should start now.
should we start?
Yes, sir. Yes, sir. Yes, sir.
Okay.
Yes, Rohan, please start. Yeah.
Okay, ma'am.
All right.
Welcome, Abhishek.
Thank you.
Okay. Good evening, everyone. Our constitution is the supreme law of the land. Dr. B.R. Ambedkar has rightly said that constitution is the vehicle of life and its spirit will always be the spirit of age. On this note, I welcome you all to the public lecture on the topic Constitution of India, Secularism and Quest of Hindu Rashtra, the intersection of correlation. Today we have with us Dr. Abhishek Mishra sir, Associate Professor, IIULAR Goa. Sir has obtained his PhD from University of Hamburg, Germany, and LLM from NUS Singapore. His field of interest is constitutional law, international commercial arbitration, and corporate law. Now, I would like to invite Dr. Abhishek Mishra sir to deliberate on this topic. Please, sir.
Thank you, Rohinji, for your introduction to me. And I would also like to welcome or say my hello to my colleagues, Dr. Yashomati Ghosh, Dr. Abhik Majumdar, and the show face behind the show, Ruchita ji, and all my dear students, past and present both. So today we are going to discuss, and I would like to, raise more questions than to put answers forward, because it is the rationality or the thinking behind a concept that makes it clear for us. So that's how we perceive it as. So I have always been puzzled by this concept of constitution. This word has always kept me disturbed. What does it mean? How does it start? For example, when we say that Constitution of India, what exactly does it mean? For its constitution, uh, first of all, those of you who are not that much aware of the subject, the constitution, the constitutional law, and the law are three different things. There's no doubt about it. So, for example, if we read the preamble of the Indian Constitution, it says that we, the people of India, having solemnly resolved ourselves to constitute India. So that means people of India gathered together and then they gave this constitution, what is known as Constitution of India, to themselves. That means those who were sitting and drafting the rules and regulation, they were basically the people of India. Otherwise, we also had Government of India Act. What was the problem with the Government of India Act? Why didn't we call it Constitution of India Act? And why did we call the what is the distinction between the Government of India Act of 1909, 1950, 1916, 1919, then 1935, and then the Constitution of India? So what we call constitutions, others call as government. For example, when a person in America, he sees us, he tried to understand our understanding of a phenomena. He sees it from the prism of the governmental policies, right? So when you say Government of India, that's basically is Constitution of India for the what we call external point aspect of a rule or external aspect of perception of something. For us, Constitution of India much deeper than what it is, right? So it is in that regard the what I'm going to understand it. What is secularism in Constitution? Because we are Indians, we have created this Constitution. This Constitution has not created us. The Constitution of 1915 did not create India, because the preamble makes it very clear: we, the people of India, having solemnly resolved ourselves to constitute India into a. So it's a transitionary book. It's a transition of the old governmental structure to a new republic model of governmental structure. So that means India, people of India were there always, right? what they did, they transformed themselves from being a subject of an empire to the subject of to the citizen of a modern republic. But how did Indian come into existence? Who was the first person who said, I am an Indian? And is India and Bharat one and the same thing? If not, then what is the difference? If being an Indian and being in Bharat is not one and the same thing, then also comes the question, how do we perceive the idea of religion? Is the religion that have constituted us? For example, if you are Christian, then you have to have a Bible. There can be no person on the face of earth who can claim to be Christian, but then is not associated with the Bible. You can be a German and not associated with the Bible, but in order to be a Christian, you have to be associated with the Bible. You cannot be Christian without. The same is for Islam, the same is for Judaism. So the Constitution, has it dealt the religion in a way that the Abrahamic faith deserves or understands? Or have we dealt it in a different manner? Have we accepted and embraced others' problem as our own problem, and then have started manifesting the constitutional principles and rule accordingly? So are we, being the people of India or the people of Bharat, being governed by the principles and the rules that are basically invented to solve the problems essentially arising in West? And is secularism, or was secularism, a need of the Bharatiya social problem, Bharatiya political problem, or was it a Western political problem that that makes it relevant for us? This is what the juxtaposition in which I'm going to make you understand that what is it that we mean by the term secularism, the Constitution of India, and where does the scheme of Hindu Rashtra, which is an N word, because if you say Hindi word, Hindu Rashtra, and you conduct a vote in any group of people who claims to be educated, I'm quoting the word educated, the overwhelming majority will say India is not a Hindu Rashtra, without knowing the meaning of the term Rashtra, without knowing the meaning of the term Hindu. But they are in a hurry to declare India as a non-Hindu Rashtra. Answer is why. They do not, they have no analysis. They do not know why. They barely understand it in terms of majority and minority. And that minority happens to be the Abrahamic minority of Islam, nothing more than that. I would also request you to understand that if those of my students who have read Article 16 of the Constitution of India, which basically talks about the reservation and the necessity of reservation in Constitution of India, they will find that the judgments of the Supreme Court is filled with the analysis of how the Indian social order prior to the adoption of the Constitution and the enactment of the Constitution of 1950 was basically marred with the caste hierarchy, and that caste hierarchy needed the rationalization, or is the rationalization behind the preferential treatment in form of a public employment to be reserved by certain section of the people. That's the justification. So rule is not important, but the rationality behind the rule is that the Indian legal system created a caste hierarchy which was unjust to certain section of the people, because there was this hierarchy suppressed many people who were part of the society from having the rightful share in the development of human growth or human aspirations. So in that context, we do not find any such analysis of the word secularism. Even the some of the important questions that I was having myself or asking myself, which I will present to you, and before I go and give the answers to many of these questions, is this. The Constitution of original Constituent Assembly discussed the word what you call secularism threadbare. They reduced, they ruled out, they said no need of India to be termed as secular, no need of, or no place for secularism in the Indian preamble or anywhere in the India, because Indians are basically secular. So what was their approach? Why didn't they make it the part of the declaration of India in terms of republic, democracy, and something else? Why wasn't there? Why didn't they understand the necessity of declaring India secular, as the today's parliamentarians or the today's politicians emphasized on? That is a question that I get confused with. Second, when the need was understood and the constitution was amended in 70s and the word secular was added, what did they understand the need of inserting the word, and what exactly changed the meaning of what exactly changed as far as the Constitution of India was concerned? And later on, Supreme Court lapped it up. The concept was lapped up, and then it was declared to be the basic structure of the Constitution. So I did not understand that if secularism was not the basic structure at the start of the Constitution, then how did it become a basic structure after the 78 years? Can you insert the basic elements in a constitution post the edifice of the constitution being erected? I mean, argument does hold the water, because you can say that the customs and convention and certain practices, which I will draw an analogy with international law for just cogence, that certain development can change the way a particular society is perceived. But the Supreme Court, without analyzing secularism, no analysis of secularism I've ever seen in any of the judgments of the secularism of the Supreme Court judgments, like the threadbare analysis of the caste system and how the hierarchy has wreaked havoc in the people's in the life of Indian social order, but no such analysis of what the Abrahamic faiths have done to India, and why the secularism is needed. I would also draw an analogy with the Hindu Marriages Act and the Indian Succession Act. Prior to that, what was the Indian Succession Act? What was the need of the Indian Succession Act? And then at the end, we will discuss with the concept of domicile, that whether India has a domicile or Bharat has a domicile and India has a domicile, are they the same domicile that we understand, right? So let's start the presentation in that thing. I will present it before you. So, Bharat.
Abhishek,
Uh-huh.
small interjection. Can you do you see the slider icon to the bottom right?
Uh-huh.
To the left of it, do you see a small icon with a projector screen? To the left of the slider. You click that. No, right next to the minus sign.
Yeah.
There we are. Perfect.
Okay.
And now it's on full screen.
Okay. So see, Article 1 says Constitution of India, Bharat, India, that is Bharat. Those of you who would go and study abroad, they will find the problem of language and the different meaning that one word may have, and how that mischief is resolved while interpretation of the or any legal document. But I'll not delve into that, because two authoritative document on the Constitution of India is the Hindi version and the English version. So the first point, the first starting point of the Constitution of India is Article 1, which says that India, that is Bharat. And I completely disagree with this proposition that India, that is Bharat, to the extent that it should not have any application beyond the part 1 of the Constitution. If you see, the part 1 of the Constitution deals with the union and the state territories, or the territory of India, as you call it. That means the territory of India, for administrative purposes, have been politically structured in a form that we understand, right? But is Bharat India beyond Article 1? I can tell you that I have seen many definitions of India that is given by the Britishers, and even the definition given by what you call Al-Biruni in his famous book Kitab al-Hind, where he has defined India. All of them has defined the physical boundary of India. So to that extent, in the definition of India given by Al-Biruni, who had never visited the length and breadth of India, but he could give a definition, explains the merit of the scholar. Same with the Britishers. They also map the geography of India precisely by saying the minute coordinate exactly that this is India. Even the miles, if you read the history of states by Sir Elphinstone Stone, in his book, he says that this is what India is, right? So how did they know it? That's a question that I have always troubled with to see that. But anyways, my first question is that, is the perception that India, that is Bharat, has an application beyond the part one. I will not doubt the application within the part one, because I have tallied that all the scholars outside, those who came from outside India, they have given the geographical definition of India in the same manner as the Indians themselves have given to themselves. Because as you, for example, we can draw an analogy. If you see the part 3 of the Constitution, it says that the definition of state given under Article 12 is has a limited application to that part. So to that extent, that India, that is Bharat, shall have limited application as far as the territorial boundaries of the India is concerned. Beyond that, the definition that India, that is Bharat, is not a right perception. It is in fact completely different, and I'll show that how it is different. That India, that is not Bharat. Okay. So I'll just read out. India, that is Bharat, mentioned in Article 1 of the Constitution, is morpheme used as a synonym with India. Nevertheless, Part 1 Constitution of India refers to territories of India. It doesn't explain the soul and essence of India. Therefore, Bharat and India cannot be compared beyond the boundaries of the territoriality of the constitutional interpretation. Every part of the Constitution has its own significance, and its meaning are restricted to that particular part. For example, Part 21 of the Constitution of India deals with the transition of the transition of India from being a dominion to a sovereign republic, and that transition from being a dominion of the British India to a sovereign republic had a lot of legal and social and constitutional challenges, which were dealt essentially in Part 21, right, of the present Constitution. So Article 1 is a code in itself. It's a constitution unto itself as far as the territory is concerned and the political map of India is concerned. Right. For example, Article 21 also lays down the essential principle that India shall always be a federalism. Government of India Act 1935 tried India to be a federalism. It failed miserably. But what was failed miserably under article in the Government of India Act was basically achieved thousands of years ago in India, when India was already called the sum total of 16 Mahajanpad, the 16 Mahajanpad, those who functions within the realm of India. Is India, that is Bharat, same beyond Article 1? Let's see. Right? Present day Constitution of India is basically the Constitution of Government of India. What is the Constitution? You find Part 1 territory, Part 2, then you find citizenship, Part 3 fundamental rights, then you go to Part 4, which is DPSP, Part 5 is the structure, governmental structure of union, which is union executive, union legislature, union judiciary. Then you go to the state, then you go for a relationship between them, the states and the other parts. Then you come the financial relationship, the financial implication, emergency provisions. This is all related to the governmental functionality, right? And all related to the governmental functionality. But Constitution of India is in essence is the constitutional government of India, right? Beyond that, what makes us an Indian? It's a different question. Because Constitution of India doesn't give you the essence of what makes a Bharatiya really a Bharatiya. Constitution of India of present day indeed is an extension of the Government of India Act 1915 as amended in 16 and 19 and Government of India Act 1935. Now, as I told you that the heart, while explaining the rules and then how the rules to be valid interpreted in terms to extract the meaning, different people may have a different meaning, the open texture of law. He gave he come to an idea where he says that rule may have an internal aspect and an external aspect. The same with the Constitution of India. The internal aspect when the Indians sees themselves and how the outsider sees themselves. For example, I've told many times in my classes that when I was in German, two German will meet each other. They'll say, Ich bin Deutsch. That means I'm Dutch. But the same German, when meets with a non-German, he says that, hi, I am a German. So Deutschland and the Germany are the same. That's not really the case. We will never understand what is Reich, what is Third Reich, and what is the meaning of the term Reich if we just understand Germany. Because Reich essentially is a Deutsch concept, not a German concept. So comes the question, are constitution and governments identical terms? And I'm not talking about constitutional law, because constitutional law is a law of government, basically. It's the laws of the relationship between the people and the government's inter se. For example, how Rajya Sabha and Parliament, how Rajya Sabha, that means Council of State, is placed vis-a-vis the House of the People. What is the relationship with the president and the House of the Council of the State? What is the relationship with governor and the president? What is the relationship between the chief minister and the governor, and so on and so forth? So are constitution and government identical terms? Because Britishers, why didn't they create the Constitution of India Act 1935, Constitution of India Act 1919? These questions should disturb someone. So Secularism and Government of India Act and Constitution of India is the next analysis that I meant to. How did the Government of India Act deal with the secularism? Did they separate the religion from the government? Because essentially the meaning of what the Indian constitution, Indian courts have dealt with secularism, seeing it as a neutrality of the state vis-a-vis a religion, which is not secularism essentially. Where it was born, secularism, it was a strife with the church and the people of that country. Would you say that the strife with the mosque and the people of Arabia will be the same result of secularism? We'll see that. So the strife with the Ved and the Dharma Sutras arising out of Ved, where they wanted to implement the constitute the legal order in terms of the philosophy. And those of you who want to understand the distinction between principle, policy, and philosophy, a very good article written by Dworkin and his Taking Right Seriously. It's called as Hard Cases. So policy, principles, and laws, they are not all the same thing. But anyways, those of you who want to read, they should go and see that. But how did the Britishers, who gave us the constitution, secularism? Who brought it to us? Did we need it prior to the invasion of India in form of Islamic invaders? Or did we need it after the Britishers came to India? When did India introduce itself to the secularism? Did we deal with the concept of secularism, or did we deal with the concept of religion essentially the way Abrahamic faiths have dealt it? Is the concept of religion same in Vedic literature or other literatures same as the Abrahamic faith? We need to analyze it. Without that, we cannot understand secularism, because it comes from outside. It's an imported constitutional principle. But I wanted to understand whether the Government of India Act, what did they do with the secularism? Let's go to the next one. So let's analyze the provision of the and secularism. For me, and very clear, separation of church from the state. So Government of India Act, I was stressing that anything in the Government of India Act which basically separates the church from the state. That because in Europe, the legitimacy of the government, which is constitution, who will rule you? The laws of the God. Sometimes they call it natural law. Some scholars call, no, that's not natural law. Divine laws are not necessarily natural law. There's something else. But who will govern you? What identity of a German as a Christian or as a German would be prevailing over him? Because the state that we call the sovereign state, not the Indian state, is basically a Westphalian system of states. Why the Treaty of Westphalia took place at the first instance? Because there was a fight between Protestants and Christians and Catholics for 30 years. Why were they fighting? That's not the subject matter of this case, this presentation. But they were fighting in the name of religion. Did we fight in the name of religion? So some of my European friends that, we gave the word freedom of speech and expression. I said, you are not even close to the idea of freedom of speech and expression. It is us who understand the idea of freedom of speech and expression, because Lord Buddha is the freedom of speech and expression for us. When he said that all the gods mentioned in the Veda are basically nonsense. There is no rebirth and all that. There is one birth. All your pain and pleasure are basically here because of your, physical life. He denied Veda. Can you do that at that time in Europe? Criticize Bible or criticize Quran, and then you would survive? Or the person who's criticizing it would be given the status of a lord or a god? Darwin got afraid that his findings that there is an evolution of human being would put him in trouble with the religious people in Europe, because theory of creation is contradiction of theory of evolution. I am not saying that they have established. Theory of creation also has a lot to answer, and theory of evolution has also a lot to answer. but at least the ability to say that there is a theory of evolution. It is important whether the theory of evolution's contents are correct or not is not my argument. So anyways, so I went to the Government of India Act 1950. And I found that when the Britishers were created, for example, UK is not a secular government, it's a Christian government. It has and keep that wide establishment, ecclesiastical establishment, the word you should keep in your mind, because then only you will understand when the Constitution of USA was being framed and they had a secularism in form of non-establishment clause. This is what exactly they were denying when the Europeans were creating a society outside the Europe. For the European, they said that there will be no ecclesiastical establishment, but when the European were creating a society outside the Europe, they said yes, there will be ecclesiastical establishment. What is ecclesiastical establishment? That needs an answer. Are they separating the church from the state, or they're embedding the church to the state? Those of you who want to see this, they can go to the link and then read how the ecclesiastical churches were established. The powers were given to bishops, and other kind of church structure was introduced to the India. Were they introducing secularism to India? You are free to decide. Nevertheless, I thought maybe an article, when we go to Government of India Act 1919, which was within 4 years of the 1915 Act, they might have done away with that, right? So, I mean, these are the relevant provisions. You go Government of India Act 1935, Part 10 dealt with the. So, I mean, this also in the Government of India Act 1935, they kept the provisions for what you call ecclesiastical establishment. They did not done away with. They simply kept it. They did not do away with it, right? So if you can, on the contrary, they established a system of chaplains for the structure of church to take place in India, right? So Government of India Act 1930 established chaplains in India, and those who want to go, they can go to the Government of India Act, Chapter 4, Part 10, which dealt with the concept in Section 269 of the Government of India Act. Government of India Act 1935 established chaplains in India. What happened to the ecclesiastical? One may ask that whether chaplains simply did away with the establishment. No, Government of India Act dealt with them by granting Governor General the power to exercise necessary power related to the ecclesiastical establishments, the budgets and all that. So following provisions of the Government of India Act dealt with the ecclesiastical power that was to be exercised by the Governor General of India. Section 11, Section 32, Section 100, Section 33, Section 122, 23, Section 269, Section 330. Item 4 of the Schedule 7 of List 1 listed the subject matters over which federal legislative government could enact ecclesiastical matters with the word in power of what you call federal legislative. That means what is equivalent of it would be the present Parliament of India. Did these provisions, again, the same question, did these provisions separate the church from the state? Or did they embed them more firmly? They introduced it to India. Ecclesiastical affairs and dharmic affairs were not the same. They are not the same. I have taught my students a case in the family law where what happened that one Brahmin Hindu, his one wife died, and then he married to a Christian lady, and then they had the 2 children from the Christian lady. The guy had children from Christian lady, and the guy also had the Christian children from the Hindu lady. So when the Hindu children and the children from the Hindu mother and the Christian mother, they were fighting for the idea of inheritance. The question was very tricky question, because the girl was Christian, the boy was Hindus. So one of the question is that how did the personal laws of Christianity and the personal laws of Hinduism solve it? And by the way, personal law is constitution basically. Well, we shall see that here later on. So dharma is not the same as religion. Those who try to even draw a remotest analogy are doing injustice to the grand scope of the word dharma. Dharma is not human-centric. Religion is essentially human-centric. For example, the women get a menstrual cycle. You call it masik dharma in Hindi. I mean, if you will use the word religion or deen for these kind of things, which is considered as bad, you would be perhaps committing, because one of the idea behind the Jannat is that the women or the hoods, they will not have these kind of bad things, which you call excretion, the coughs and menstruation cycles. They would be pure of this impurity. That's make them. So if you will use the word for something which is considered as impurity, you would be committing blasphemy. But dharma is not that. So you can distinguish a man and a woman from the masik dharma. The man will not have a masik dharma, but the woman will have a masik dharma. Dharma is that what you call wider or comprehensive. Anyways, let's continue with our journey of secularism. India, on the contrary, is a land of... So Bharat is a land of dharma, but India is a country of ecclesiastical matter. That's what I wanted to say, that India and Bharat are not same. India and Bharat are not same. If you are a Bharatiya, you would talk about dharma, but if you are an Indian, you'll talk about ecclesiastical, because even the Arabian will not call you Indian. In the hitherto, 200, 300 years ago, they'll call you Al-Hindi, as did the Mughals. The Kitab, the book written by Al-Baruni is Kitabul Al-Hind, not Kitabul Al-India. So India, I could have added Hindustan in my analysis, but that would have made me work so much that I would have gone crazy. But anyways, so this is clear. Ecclesiastical matters were introduced to the government of India. And hence, Bharat and India is not same. Because Lord Buddha, when he rejected dharma, when he rejected the Ved, did not introduce laws, did not introduce the idea of the parish governing the Buddhist religious affairs, ministries, and they will change the laws and all. They were all philosophical debate, whether there is God, transcendental, not transcendental, is there a God at all? These were the philosophies. They were not concerned with the constitution of the India. That means the laws which will solve or create legal rights and obligations vis-a-vis government and for themselves. So Bharat and India are the same? I am pretty sure that they are not. And it is established by the analysis of government of India, and we shall see the Bharat's constitution of Bharat too. You can see Fatwa-e-Alamgir, Masir-e-Alamgir, Babarnama. I could have quoted many of things when in the 12th year, the Aurangzeb said that destroy all these schools in Sanskrit and all, because these nonsense Brahmins are simply preaching their ugly faith and the wrong faith, and they are not only confusing the local Indians, but the converted Muslims too. So Hindustan also did not separate religion from state either. Akbar, the great, generous king, changed Allahabad changed Prayagraj to Allahabad. He even couldn't to the local place. So Hindustan is also not the same. Now let's see the domicile. The interesting part is the domicile. What is domicile? The essential laws that develops. The people saw the marriage in India as different phenomena. The property is a different phenomena. Their idea, for example, cow was a property in India, where cow is an edible entity in some other part of the world. You can't. So this is constitution. In other parts of the world, there may be other entities. For example, camel. For example, the horses or other belongingness could be the property, but not the cow. So social and geographical realities forms the laws which you call domicile, right? So if you read section Hindu Marriages Act, and I think Hindu Marriages Act is a very poor legislation, very poor legislation. It changed the meaning of the term, first of all, Hindu. Who is a Hindu? Because Hindu is a Gentu. For all intent and purpose, Hindu, for an Britisher, is a Gentu. When he came to India, initially he said, he heard the word, he said, who are these people? He says Gentu. Same for the tribalism. Tribal concept of tribalism you will not trace in any Indian text. Indian text explained the group of human being only in 4 parts, the Varna system. Beyond that, there was no other idea and identity given to any group of human beings. It's the Britishers with their perception of the word in terms of biblical realities. They mapped the Indian population in terms of Hindus, Muslims, Christians, tribals, non-tribals, and all that. Otherwise, to say that tribals are tribal because they have a spatial way of life, I mean, whose life is not spatial? That's nonsensical. So I have a friend who was tribal, and his father was a big minister in the central government of Congress as well as the BJP, Bhuria. And I saw him worshipping Lord Shiva. I said, what the hell is that? He said, that's we have been worshipping Lord Shiva for thousands of years. So, I mean, but I said, you're tribal. So yes, I'm tribal. Now, what does it mean? You don't know. Because the Britishers did not know. We changed the Indian lenses and put the Western lenses to see how, and we are continuing with that, unfortunately. Anyways, so let's see how beautiful, apart from how Hindu marriages simply distorted the concept of marriage. As I told you in that case, I've taught to my students that in personal laws of the Hindus, where I say that a Brahmin man first married a Brahmin girl and then married a Christian lady, and then when the judge had to analyze that how the Indian laws hitherto, when these things were not, for example, those who want to read this case, they should go and read this last 3 pages. Written by Supreme Court judge. If I had a time, I would have shown you. What did he say? How this, because of one person who couldn't understand whether to apply equity, fair and good justice or the laws of Hindus or all of the Muslims, because he didn't see them as Indian. They saw it Indians as in forms of caste and all. Indians never themselves saw in the terms of caste and creed. That was the legal perception, but the social perception was not there. Socially, you were Indian. उत्तरम यत्र समुद्रस्य हिमाद्राय शैव दक्षिणम वर्ष तद भारतम नाम भारती यत्र संतति नाम भारती यत्र संतति. So let's see. Anyways, since at that time, we were all being educated in Europe, and then Sanskrit was rejected as a law, as the language of the land, and English was preferred for some inexplicable reason, as if English will come and give us some superior knowledge. And I can understand that in contemporary world, Indians were seeing many things that make them believe that it's the problem is within us and solution lies outside. And when Europe comes with infection, and this is a beautiful infection. Europe grows. English is a language. The Britishers have done all sort of wraths to the all sort of trauma, tragedy, killing, maiming, raping, everything. We have accepted English. It's beautiful. Europe grows. Europe is in, anyways, we'll see that. So how does Section 2 reads Hindu Marriages Act? It says that it extends to the whole of India and also applies to Hindus domiciled in the territories to which this act extends who are outside the said territories. The last two sentences are very critical. So Hindus domiciled in the territories who may be living outside. The law also goes after them. And it would have been always the case, not just by virtue of Article 245. Because Parliament couldn't have had the power to make extraterritorial laws for non-Indians. So the law is saying that domiciled in India. And what is Hindus domiciled in India? What is that? What is domicile? Right? In the territories means, because if you read the original law initially, it says that the part extends to the whole of India except Jammu and Kashmir. So because of the drafting issues, they couldn't have used the word whole India, and they had to take out the territory of Jammu and Kashmir from the application. Hindus living in the Jammu and Kashmir from their application of the extraterritorial application. So they said the act extends. So the act didn't extend to Jammu and Kashmir. The act extended to all other parts. And at that time, if you see, there were other amendments also mentioned. The act extended to all other parts of the territory of India. So if you were a Hindu living in those parts of the India and staying outside of India, the law will apply to you. What is this domicile of India? Domicile that we call That's the constitution. The governments and the structure of the governments will come and go. The law basically extends, so I have explained that part, right? Now, if a Christian or a Bharat of a Muslim goes outside, what personal laws would they be subjected to? Now, Christian, let's say those who were born in India, I'm sorry. So Christians, European Christians, they were born in India. Did they acquire the laws of India? Because when these laws were developed, the Indian society did not know of anything who were beyond the definition of Varna system. And even if they knew that there might be different philosophical explanation of the God. But they were not expecting that with the different philosophical explanation of God comes also the different laws. They were not ready for that. For example, when the Ved came, right after some time, it was rejected by Indians, some of the scholars who were called Charvak, although very literal interpretation, very literalist, and what is visible, that is only the truth of the word. That's a very, very literal interpretation. But then whatever it is, that's not important. Whether their philosophy holds good with the laws of physics or not, whether the philosophy of Ved holds water with the laws of physics or the laws of chemistry, we understand now or not, that's not the question. The question is that you gave a philosophy and others rejected the philosophy. The question is that what was the domicile of those who were subscribing to the Ved and what was the domicile of those who were subscribing to Charvak, those who rejected Ved? Did the domicile change? What we call here personal laws, basically. Now, when they were changing the faith, they were being governed by the domicile of Bharat. So you become Buddhist, doesn't matter. You are still your laws of the succession and everything remains the same. That's not a problem, right? Anyways, so when they were changing the faith, they were being governed by domicile of Bharat and post-convergent domicile of India or domicile of, and this only happens when the Abrahamic faith comes in India. You can't simply brush it under the carpet and not going to analyze the Abrahamic faith philosophy just because you are shy of doing that. You have to call a spade a spade. They have analyzed, we have to analyze, because as I said, no Indra Sahani would be possible without the analysis of the caste system. No Mandal report would be possible because of the problem, without the problem of the caste system. So you have to analyze that. Now let's go to the next part. The question is, domicile of Bharat and domicile of India the same? Answer is no. The domicile of Bharat and the domicile of India is not the same. And how would I prove that? Because I'm running a little bit. These are the cases. An interesting case, one can see that how a man kept on changing his, he was an Indian, went to Sweden, became a Swedish, then he became Australian, then he became so on and so forth. And then the question was that whether the Hindu laws, Hindu Marriages Act would be applicable to him or not. But because of the time, I have to rush forward, right? So the Supreme Court had to answer in this case, what happened in the Sonder case, had to answer a difficult question of relationship between domicile of origin, domicile of choice, by attributing a domicile to the parties for asserting the jurisdiction of the court for grant of remedy. As she explained, domicile are of three kinds: origin, domicile of operation of law, and domicile of choice. But the point is that the latter two domiciles are not possible if there is no domicile of origin. The operation by law, that means, let's say I'm a Hindu living in Australia and then I bear a child with my wife, that person would be given a domicile by operation of law. And that domicile will come from me, not from the place of birth. Domicile of origin and so anyways, domicile of origin is not necessarily the place of birth. The birth of a child in a place during temporary absence of the parents from their domicile will not make the place of birth a domicile of child. This is Supreme Court's word, and rightly so, because before that, the Calcutta High Court gave a very, very horrific judgment when they simply misinterpreted Section 1, read with Section 2 of the Hindu Marriages Act. In domicile of choice, one is abandoned and another domicile is acquired. But for that, the acquisition of another domicile is not sufficient. Domicile of origin prevails until not only other domicile is acquired, but it must manifest intention of abandoning the domicile of. And how would you infer the manifestation of intention? That would be fact to fact. So as we further explained, in that case, the right to change the domicile of birth is available to any person not legally dependent, and such a person can acquire domicile of choice. It is done by deciding blah, blah, blah. So I will cut these parts. Therefore, the application of HMA, and you see section 2 also gives a very interesting position. The application of Hindu Marriages Act may also extend to those who are Jew, Christians, Muslim, and Parsis. One of the questions is that why the Sikhs and the Jains and the Buddhas and so-called Hindus are being clubbed. Basically, Hindus are given as one independent identity, and also the Hindu are the cluster of various what you call philosophies of God in India. So I'm a Hindu, and at the same time, Hindus are also those who are Buddhists and the Jain and also. So I don't understand whether, for example, Bharat, that is India, shall be the union of states. So if you take away the union, which happened in Article 370, that if you simply bring out a law and say that all the states are converted into UTs, so India will cease to be a state of federalism. It will become a unitary government. So India will not be India if it will not be manifested through the plurality of its people. So Hindus are Hindus, and Hindus are also some total of Buddhists. This is also a perplexing position that shows that how the people were not really understanding what is going on. If I'm a Hindu, it includes that I'm a Sikh also. If I say that I'm a Hindu, and what will make me Hindu? Because I'm a Jain, I'm a Buddhist, I'm whatever religions are, and if you're calling them the religion. Anyway, the interesting part is that those who are Jew, Christian, Muslim, and Parsis, and the word is for such persons, if the latter, because of the interpretational ease, I have explained that when the section uses the word such persons of the HMA, they basically means these persons. Unless it is proved that any such person, that means the Christians, Jews, Muslim, Parsi, would not have been governed by Hindu law or by any custom or usage as part of that law in respect. So even here, the Hindu Marriages Act is saying that irrespective of the fact that you're Jews, Christian, Muslims, and Parsis, there is a possibility that the domicile of India would be extended to you. Right? There is a possibility by the custom, and how is that possibility manifest? You need to go and see the Indian Succession Act. An interesting case was there in Abraham versus Abraham, where the Privy Council held in a case that Mr. M. I'll read off the fact. Mr. M. Abraham's ancestors were Hindus who were converted into Christianity. On the death of M. Abraham, his widow brought the suit for recovery of his property. The suit was raised by his brother F. Abraham, who contended that his ancestors continued to be governed by Hindu law in spite of the conversion. He accordingly claimed that he was entitled to the entire property according to Hindu law of survivorship applicable to joint Hindu family. Now, a Christian is saying that I am still governed by the Hindu law. If your judges are English, what would they define? Would they accept this contention? Of course not. Of course not. If it was not the Privy Council but the Indians who knew their system, they would have said, yes, he is Hindu. And Privy Council accordingly said that also. It said that you cease to be, but then you have an option. So at least they were accepting that because of the problem of the proselytization and the introduction of the new sets of law, there is a problem of conflict of laws. So what did they say? Held that upon the that upon the conversion of a Hindu to Christianity, the Hindu law ceases to have any continuing obligatory force. Anyone who understands Christianity, they understand that one of the conditions of becoming a Christian is this, and so is the Muslim, that you cease to be governed by the law, which was not the Indian idea of religion. They say that if you have changed your faith, what you have changed is the idea of the celestial creation, or the God, or the karma theory, or what explains pain and pleasure, but not the laws. But the Abrahamic faith insists not on the freedom of religion in terms of the reverence of a god. It says that it basically means adherence to the god, the laws of the god. Hindu law ceases to have any continuing obligatory force upon the convert. But the same thing, if you read that case of a Brahmin man marrying Christian and all that, the Hindu law says that no, if an Indian marries to an outside, because he would not see the world beyond the caste system or the Varna system, they say the marriage between a Shudra girl marrying a Brahmin boy or a Brahmin girl marrying a Shudra boy is a legitimate marriage. They never rejected the marriage. So the Privy Council understood the problem, and because they were being Christian, but at the same time they were also aware of the distinction between the European.
Am I audible?
Yes, sir.
Yes, sir. Yes, sir.
I think Abhishek sir he's facing some sort of a network issue. Let me call him. Sir, I think that you have encountered a network issue. Yes,
So
sir.
your mic is
Abhishek,
closed. Abhishek, sir, your mic is closed.
Abhishek sir, your mic is.
Okay, so बहुत ज्यादा छूट गया क्या?
Sir, I can
Those
hear
three,
you, sir.
in about 2-3 minutes.
Okay, so what I was saying that, see, if you see this that Hindu says that you are a Christian but you may be Hindu also. That's the same thing is also said by the Privy Council. The Privy Council enunciates two principles. One principle Privy Council says that the effect of a conversion of a Hindu to Christianity is that to sever his connection, जो एक भारतीय क्रिश्चियन या भारतीय मुस्लिम बार बार कहता है इस प्रिंसिपल के अंतर्गत कि I'm a Christian, I can't be Hindu. But what is the second principle enunciated by the what you call Privy Council? It simply says that civic council, इसको सेंटर में ला सकते हैं क्या मेरा वो जो है presentation? Can everyone see the presentation? Okay, so if the second principle says that such a person may renounce the Hindu law but is not bound to do so, he may elect. So those Christians who want to still considered as Hindu because वो Hindu law से governed हो रहे हैं, the Privy Council say that yes, you can do that. So ये जो हमारी जनरेशन, so दो प्रिंसिपल है. एक हिंदू ये कह रहा है कि तुमने गॉड चेंज कर लिया, इट डजंट मेक यू सीज टू बी अ हिंदू. एक क्रिश्चियन कह रहा है नहीं यार, मैंने गॉड चेंज कर दिया, आई सीज टू बी अ हिंदू. How did the Britishers, who were basically the Christians, how did they see that? They were lords. They were basically well versed with the Christian laws. They are saying that because they understand that Bible creates the laws of the God are not domicile. The laws of the God are universal. They cannot be based on a particular law of a land. So the domicile and the laws of religion are at clash, because if you change your faith, your faith basically comes in conflict with the laws of the local land. अब बाइबल का कौन सा या कुरान की कौन सी लोकल लॉ है? ये यूनिवर्सल लॉज, दे आर क्लेम टू बी द यूनिवर्सल लॉज, right? So rightly so, the Privy Council understood it, that it's an Indian converting to Christianity. So he might be related to a wife who is a non-Christian, might a family which is non-Christian. They understand the Mitakshara law, and the in South India you have a Mitakshara, in North India or other way around, the Daya Bhaga and all that. So the Privy Council gave them the flexibility. What a church person might not have done, but they did. The third option was that. So for the even Privy Council say that if a Christian wants to say that I'm a Hindu because I'm governed by the Hindu laws, you're free to do that. You might not say that I'm a Hindu because I also revert to the Hindu God system. That's perfectly all right. The course of conduct of the convert, and this is the Privy Council, the course of the conduct of the convert after his conversion would show by what law he had elected to be governed. So you have converted the God, but if you still abide by the local laws, as I said, that the Bible cannot have a domicile. Bharat has a domicile. Ved doesn't have a domicile. But the local laws have a domicile. Yajnavalakya Smriti, the Manu Smriti, and the other Smritis, Daya Bhaga school, and they are the domicile. So if one of us converts to Christianity, welcome, no problem. I love Jesus, I love Allah, I love everything. Because that's what makes me an Indian. But the problem is that, the issue of secularism is not the clash of God. India welcomes all kinds of gods. It's a clash of laws. Right? Anyways, let's go to the next one. Sorry. Domicile of Bharat again. Under the third principle, it was found that Mr. Abraham, decision tha, because of course they were Britishers and they could not have come to any other conclusion. You cannot say that the judge is devoid of the understanding of a situation beyond what he has been taught to. Now, this domicile of Bharat was, that means domicile of the problem of domicile and the religious law, which is a universal law. Because see, when you are converting to Christians, are you converting to the British law of domicile, or are you converting to the laws of Bible, which is not British law? So this principle that was laid down in Abraham, and Abraham was extended to many other decisions by the Privy Council, which made the Britishers understand that there is a problem of laws, and in order to solve that problem of laws, they came up with the Indian Succession Act 1865. So what they did by a stroke of a pen, but they understood over a period of time by converting and proselytizing people to Christianity, that you need the law in order to effectively apply the laws of succession and all that. So they were constituting again India. So Indian Succession Act 1865, when they were simply solving the problem of the clash of laws, of the conflict of laws. If you read Indian Succession Act 1925, which basically succeeded 1865 and consolidated all other succession act for the Christians, you find that most of the part of it say that it is not applicable to Muslim, it is not applicable to Jain, Hindu, blah, blah, blah. And why did I say that? If you read the judgment of Narasu Appa Mali, which was again a blunderous judgment, that they said that since in the section 112 of the Government of India Act 1915, they did not use the word personal law. They used the word personal law along with the custom and usage. Therefore, in 13 clause 3, we do not have the word personal law. That means we didn't want the personal law. But they did not understand. They wanted to create a ecclesiastical system of the government for India. How can you read Article Section 112 of the Government of India Act without understanding the entire structure of how government to be explained in the Government of India Act? But anyways, so the problem is the personal law. On one hand, you have domicile, that is a personal law. On one hand, you have change of faith. On the other hand, that the faith comes with the law, which is not domicile. It has no concept of domicile. It's universal. So your domicility is severed with the change of the faith. Does it? And the Britishers had to answer it by enacting section under Indian Succession Act and all that. Now, what happened in our constitution when the Constituent Assembly met? Unfortunately, the Constituent Assembly saw, because they were preoccupied. They were preoccupied with the partition of India. Again, they were not going the relationship of the church and the state, and then how they were basically concerned that how the social fabric of India, which has just suffered a partition, shall be maintained by simply states, states protection to what they call minority, whereas the constitution didn't give any right to the majority. On the contrary, the majorities were stripped of certain rights which were given to the minorities in form of Article 29 and 30. But the mind was occupied, and rightly so. But what had happened to India in the form of the partition of India? And if you see, when the secularism was being discussed, Dr. Bhimrao Ambedkar said that no need of secularism in India. And then all of a sudden, secularism comes back, makes a re-entry in India. So, concept of secularism inevitably requires understanding of the. So, if anyone writing a judgment, at least write down the Abrahamic faith. Without that, you cannot explain the secularism. You have to explain that monotheism as a concept was introduced by the Jews, and the Jews had an idea that in their scheme of various prophets who have brought sometimes laws, sometimes contract with us, God, they're called the God of Israel, a local God. It was not the God of world. All the prophet came from the descendancy of the Abraham, not from outside. So they had a theory of creation of human being, and there are thousands of creation theory, how human came into existence. There are thousands of them. One is Abrahamic faith, Judaism theory in the book of Genesis. One of them. There are contrary theories available. If the validity of a theory is the sword, the might of the sword, then that will be a question we need to answer. We need to ponder. But then what happened with the Jews? So Jews say that the whole system of monotheism is based on the concept of the destruction, or what we call the judgment day. It is a crucial element of the faith. And in India, it is contrary. In India, it was that the creation, that means the Prakriti and the consciousness, the Brahman was always there, and then they keeps on meeting. One Prakriti destroyed, another Prakriti gets created. So we will never have the concept of judgment day, because the earth is not as a standalone concept in the universe we saw. We saw universe as a cluster of many things, and we might understood at that time, maybe very remotely, that there are thousands of destruction of the thousand time destruction of the earth, like structures, and then again recreation. But this is not the idea of this Abrahamic faith. In Abraham and Judaism, the idea is fixated to the idea that the earth is a very unique thing created by the God, and this earth is going to destroy, and with that everything will come to an end. Everything will come to an end, called Judgment Day. This is a crucial belief system. But we do not have a Judgment Day. We cannot have a Judgment Day. So what happens is that, so in order to explain their system of religion, they said there will be coming the prophet, last prophet would come, who will bring our temple and the peace to the Judaism. What happened exactly? Other way around. Two prophets thereafter came, Lord Jesus and Prophet Muhammad. Did they bring peace to the Jews? If the Christianity exists, Judaism should have finished. But who became the Christians? Not the people of the descendants of the Abrahamic clan. They became the people of Europe. They were not even remotely related to the Abraham. So they took the idea of monotheism and then sorted it with their cultural practices, and boom, Christianity was there. So the principles, tenets of monotheism with the pagan cultural system. For example, I love the festival of Christmas. When I was in Europe, I loved it. The idea of gift, the idea of snow. But I was wondering that was there a snow where Jesus Christ was born in Bethlehem? I had no answer. I think it couldn't, because it's a warm place. So the point is that then came Islam. He said, all right, we are the last prophet. And the only way you have to accept my last prophet is that you have to fight with us. Why are Jews fighting with them? At they accept Judo-Christian, at least. They accepted Christian. Europe, as I said, Europe is something very interesting and beautiful about them. The Jews accepted them. That, okay, all right, you at least accepted Jesus, he was part of our clan. They call it Judo-Christian tradition. The fact is that if you are a Jew and a Christian, you can't coexist. Because every Jew should have become a Christian if the Christianity is the right religion. Similarly, in Islam, then come the last prophet. He said that also. Are you watching TV? Every Islamic scholar says that, "Ji, Islam to shuru se tha. Islam yahan se nahi hai. Ye to last prophet, and rightly so." They said ours is the last prophet. So first jo hai, wo kisse jod rahe hain? Wo jod rahe hain Abrahamic faith se. Everything is ours. So therefore, everything was Islam, and rightly so. Their argument has a merit in it. But the question is that their argument falls flat on one part, where they do not show what Jews say, that in order for the last prophet to be termed as prophet, there are two conditions essentially to be met with, and that one of them is that Jews would get the peace. What happened after the Islam came? One can read the tenets of Quran, that how it treats the Jews. So if Islam is true, Jews and Christians both should cease to exist. We don't say that. We say that because of our concept of religion, which one must understand, our concept of dharma, that this is here. Indram Mitram Varuna Magni Maharuthov Divyasa Sampurna Grutmanam Ekam Sat Bauda Vipravdanti Yagnim Yam Matrishna Mahu. What does it mean? It calls Indra Mitra Varun Agni, and he is heavenly Garun, who has beautiful wings. The truth is one. They are not calling God is one. They're saying truth is one. But sages call it by many names or describe him in many ways. So we would, as an Indian, as a person who likes this philosophy, I would never insult any prophet, be it Jesus or be it Abraham, be it Prophet Muhammad. I can't. You can bring it many other theory, but then the Indians accept everything because of this very wide philosophy. What makes them an Indian? That if they are sage, they are saying something, it must be the truth. What's the criterion to analyze the truth is not something that we are concerned here. So we, as an Indian, as a Vedic, we accept everyone. We say you are true, you are true. But then the Abrahamic faith, they said you're wrong. You are wrong. You have to change yourself. If you want to be a Christian, sever yourself from the Indian identity. And as this is not me saying, it's the Privy Council saying that. And we are saying that no, you can be Christian, you can enjoy Lord Jesus, you can enjoy your idea of monotheism, and the earth getting destroyed and the world getting destroyed and everything will be over, and you will be granted the lease and leave and lease license for heaven and all that. All right, you believe in it's good for you. I have no problem. But they said no, that's all right, but you have to say yours is wrong. That's the problem. That's the problem. So Indian philosophy was reduced to the caste system. Jahan bhi jaiye, caste system tha, hierarchy tha, caste system tha. Brahmin was the problem of all problem. But who was that person who wrote that Sarve Santu Sukhina Sarve Bhavantu Niramya? Sarve means because they understood only Brahmins and all that, and Shudra and all. It says that Sabhi Sukhi ho, Sabhi Nirogi ho. Sabhi means Shudra bhi aa gaye, Brahmin bhi aa gaye, Kshatri bhi aa gaye. Who's writing that Om Shanti on every Jeev, every Jantu? Those comprehensive philosophy, were they that minuscule in their mindset that they saw humanity in terms of untouchability? Was there untouchability was a part of problem of India, but some people misunderstood the constitutional philosophy of Ved. For example, the whole battle of first between Supreme Court itself and then between Supreme Court and the Parliament regarding the interpretation of Article 368 and its relationship with Article 13, Clause 3. Sometimes they said law of Article 13, 368 and the law of 13, Clause 3 are not same. Sometimes they are same. Sometimes they are saying that the power to amend the constitution is in Article 245, read with 246 and 247, and the 7th schedule item, list 1 item number, the last item, and the procedure is given merely under Article 368. It's no power. Does that make constitution wrong? No. That means it gives us an idea that we can confuse the principles. We can confuse the principle. That whether the 368 is a power to amend the constitution or it's a procedure to amend the constitution, because the procedure to pass the bill under Article 245, 246 is to be read under Article 108 onwards, 211, 107, 211. There are different procedures for passing the bill. So just because, let's say, some people created in India untouchability and hierarchical system of the caste system, but does it flow from Ved or does it flow from the misinterpretation of Ved? The Vedic text never says there is a hierarchy. It says there is a division. There is a vertical division, there is a horizontal division. All of us know that. Anyways, so secularism and constitution. Who are we? How did we call ourselves Bharat? If you are Bharatiya, if you are domiciled in Bharat, you have many definitions. For example, Rishabho Maru Devasya Rishabhat Bharato Bhavet Bharatad Bharatam Varsha Bharatat Sumati Sadbhut. The Sanskrit words means Rishabh was born to Maridevi, Bharat was born to Rishabh, Bharat Varsha rose from the Bharat. I can also tell you that when in 1905 in the Mysore University, the Arthashastra was refound, the professor from Harvard and Oxford said there is a piece of shit. This book is a garbage. They were not ready to accept that Indians can write wisdom. Everywhere in the world you know the caste system of India. How did the world know about the caste system of India? Because they took it to everywhere. They did not say all other philosophies of India. A country which gave zero, which gave the Maharshi Kanad, which gave so many theories. I'm not saying we were knowing all. We were restricted, but we were attempting to know in a different way. The world knew it. We called geography Bhugol. We were not calling Earth flat and static. We gave zero. We gave countings. People were understanding, trying to understand and decipher the values and the idea. They even understood the food, science of food. They say that food can make you who you are. If you eat food which will make you angry and violent, you will become angry and violent. If you want to be cool, calm, composed, this is a science of food. Today you call them nutritionist. And you pay money for that. Anyways, so I guess I've far exceeded my time limit. I will stop it here. I am so grateful for your patient hearing, if you were hearing. But thank you so much, and I would be more than happy to take any questions if there are any. Thank you.
Now,
Thank you, sir.
Now I request participants to come up with questions. Yes, Selvi Kumar sir.
Sir.
Any question from your side?
Sir, yeah. I'm still confused that Bharat is not India and India is not Bharat.
Yes.
Will you please explain? Yeah.
So when you say you are a Tamil, and when I say you are a Tamil, for example, people down south say that in India, we are all Madrasi down south. Theek? They grudge about it, and rightly so. So in north part of India, they say that everyone is Madrasi because they do not understand that even South India, there is a division of languages, Kannada, Telugu, Malayalam, and they are all very great languages with great wisdom. The people can't make it understand. Same thing. When English came to India, he called you as India. When the Turks and Arabs came to India, they called you Hind, Bharat. For example, the Kitabul al Hind, he didn't not write Kitabul India or Kitabul Bharat. Are you getting my point, sir? So how do we understand that territorially? When I read the definition, most even you read Kitabul Hind, there is a definition of the territory of India, and they have all borrowed from the definition of India given in Vishnu Puran. उत्तरम यत्स समुद्रस्य हिमाद्रायश्च व दक्षिणम वर्ष तद भारतम नाम भारती यत्र संतति. Now, sir, I will tell you, you are a Tamil. You tell me one thing. The whole fight between Tamil and the rest of the India is that Tamil language is different from other languages, right? But interestingly, yeah, Tamil also writes or learned its language through go, 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 go. You may have one ko, go, in might not in your consonant, but you have essentially ko, ko, go, go. You do not learn your language with alif, be, te, se or A, B, C, D. You learn with ka, ka, ga, ga, But what we were presented to show that we're different. You live in down south, I live in north, I came from outside, I have a different system of understanding. If that is the case, then how come ka, ka, ga, ga, is the root of your language and ka, ka, ga, ga, and is the root of my language? What explains that? If I have come from other part of the world, I must have bring my own language. So Britishers constituted India. Hindustan was constituted by the Mughals and the Turks, and Bharat was constituted by the local people. Did I answer your question, sir?
So then, how is it possible to change India as Bharat?
No, there is no need of change. There is now need of reconciliation in these identities. The thing is that when you say, because what makes an India, if Britishers have left India, and still if in our courts we are calling our judges your lordship. In India, you never had a lord system, but you're calling it a lordship. In India, the Supreme Court's right that our customs and conventions are Westminster. How can our custom and conventions can be Westminster? Because in 1688, the Westminster itself was fighting, the king was fighting with its own parliamentarian vis-a-vis the right of the king and the right of the parliamentarians. We had a different system. Ours is a Earth Shastra system. Ours is what is written in sages of Tamil origin, sages of Apastamba, who was the Telugu sage and all. They have explained the Indian system. They never explained Indian in terms of Tamil, Telugu and all that. Indian never saw themselves in terms of Tamil, Telugu, Kashmiri and all that. Indian always saw themselves as Bharatiya. Uttaram yatsa samudrasya himadrayasya va dakshinam varchitad bharatam nam bharati yatra santati. You worshipped whatever god or you hated Veda. Doesn't matter. You will still remain Indian. This whole division with Tamil Nadu is an idea only came after 1956 as far as the state is concerned. Before that, it was Travancore, it was the presidency of Madras and all that. And Madras even doesn't exist today. What was the presidency at that time doesn't even exist. See how identities can be made and created just like that. What was the proud Madrasi? If someone says, are you Madrasi? The generation, 3 generations from now on, the students will not know who the hell is Madrasi. They will not even know Chennai was called Madras. Identity change. It's like this. But they will know they are Tamilian and they know they are Indian. As G. Sivan said. Once G. Sivan, the chairman of the ISRO chief, he was asked that, sir, as a Tamilian, what do you feel? He said, hang on. I'm first an Indian. I work for ISRO. I don't work for Tamil Space Research Organization. I work for Indian Space Research. I'm Indian first, and then after whatever identity you want me to call, I'm fine with that. Why is he saying that? And what makes, though he used the word synonymically with the Bharat, but essentially he meant, because if you are an Indian, then you are divided into tribes, you are divided into Christianity. For example, read the case of many cases anyways, I don't want to stretch my answer. So, sir, Bharatiya means Tamil is included, Telugu is included, Bengali is included, Kashmiri is included, but in India, no. No. Because Bharat never gave one formula of creation. It says that I give you Kaka Gaga, create your own language. Call it Bengali, call it Tamil, call it Telugu. It never imposed a language, that only this language is correct. This is all manufactured debates and divisions among Indians. We all are same. We have a different manifestation. No human society can understand pluralism as we do. As I told you, Lord Buddha says that the idea of God and rebirth is nonsense. He rejected Ved. But what did he do? He came in Banaras, the holiest city, to deliver his first sermon, and he found his followers there. Was he lynched? He rejected Ved. It's not the fight of God. It's not the clash of God. Secularism is not the clash of God. Secularism is the clash of domicile. So you are Tamil, let's say you were born in Tamil Nadu, your children are living in Bangalore, tomorrow they may move to Delhi and all that, but they will remain essentially tied to that village where your ancestral family was born. That's what the idea of. So no problem with the gods. But then this is the uniqueness of the Abrahamic system, that we have started visualizing ourselves from the Abrahamic principle. They reject other assimilation. If you are a Christian, you can't be a Hindu. But a Hindu doesn't reject it. A Hindu says that if you are a Christian, you can still be a Hindu. And Privy Council said the same thing. That's why in India, you needed the Indian Succession Act. It is called Indian Succession Act for all those who are non-Indians. It applies on European Christians also. And the Indian Succession, Bharatiya Succession Act in India is called Hindu Succession Act. This is the irony of this land. We are taught in our schools Latin maxim. The students do not know what the hell is Latin, where the hell is Latin. But since there is a fight between Sanskrit and Tamil, a manufactured fight, you cannot introduce Tamil maxim, Sanskrit maxim, because it will be again given a fight between the Kannadiga and other, without realizing that a Kannadiga also used Kaka Gaga or A-I-E, Tamil also uses Kaka Gaga or A-I-E. We have been groomed to see our differences and overlook our commonality. That's India. Bharat is the commonality and the differences is India. So India, that is not Bharat, and it can never be Bharat beyond the territorial definition.
Mr.
Neelkant,
Sir,
Mr.
Neil,
Sir, you are mute. I guess Neelkant, you wanted to ask a question.
yes, yes. Mr. Neelkant, you can ask your question. Then we have Veer, and then we have Khushbu. They want to ask some questions. Mr. Neelkant, you are there? Okay, Veer, you can question Veer Srivastav. Okay, Khushbu. Yes.
Good evening, sir.
Sir, thank you, sir. It's clear now. Okay, thank you.
Okay, Khushbu, you can ask your question. Then after Khushbu, Veer can ask.
Yes, good evening, sir. I just wanted to ask, sir, that do you think that this new way of advertising Bharat, which is also recently seen in the new laws, is this the right path towards changing the old British regime, as you said that they are like the trend which we use in the lordships as we use in our codes? Is this the right path towards adopting the Bharatiya aspect and removing the British regime?
As I said, that there's no need of removing anything. If you read Article 13, Clause 1 and 2 of the Constitution of India, it says that, okay, whatever was done, you can't simply go back in the time and reset everything. So you have to accept the reality we were colonized. You have to accept the reality that the Islamic invader came and persecuted the Hindus and all. But the first thing is the realization. Why to undo anything? If there was something done which is not in sync with the Bharat, that's why the Constitution, you know how Constitution comes into existence. Why Constitution? Because as I told you, the Abrahamic faith come with the world Constitution. These are for the all humanity. And they have all the principles, so you do not have right to be regulated by your own understanding of the law. You have to accept their laws. So they made the laws of Arabia as the personal law of the world. They'll make the law of the Jerusalem or the Torah the personal laws of the world. That's the problem. So Britishers, Indian Contract Act, why to remove it if it is working fine? If you have any other Indian idea, you can maybe merge with it. See, that's what I'm saying, that India is the beautiful concept of assimilation. And some things which are not assimilating, you have to throw away. And to say that only we are doing, no. The Europe came up with the whole idea of multicultural. India is the birth of multiculturalism. Tamil is a multiculturalism. Kashmiri is a multiculturalism. Bihari is a multiculturalism. The problem is that when you say Rashtra, Rashtra is not nation. Rashtra is a commonwealth. Rashtra is not even patriotism. India is a commonwealth. But since we are not English, we do not have the exact word. And there may not be exact word. What's the need of the exact word? Why not Rashtra be introduced to the English lexicon if they want to use it? So coming to your question that Bharatiya Nyaya Sanghita, first of all, the name is very, very poor name. I don't know why the criminal laws are Nyaya. But you can call it Bharatiya Dand Vidhan. That's it. Or Bharatiya Danda Nyaya Prakriya. To say that Nyaya in a comprehensive term is not, and it's a old wine in a new bottle, more or less. So you didn't change anything. There was, as I'm saying, that change only those things which are creating a bottleneck in the unity and integrity of India. But if there is Indian Contract Act working fine, why to change it? Transfer of Property Act working fine, why to change it? If you see that the Indian knowledge system will come, and when we will fuse them, accept the fusion. If we'll try to reboot, if we'll try to go back in the past and then remove everything and bring the past, then that will also be a travesty of the journeys of Bharat. We have to accept everything. But we have to accept everything with the bare truth, not with the constructed lies and the misinterpretation of the fact and the misrepresentation of the fact. That's the important thing. Truth and reconciliation is the way forward. So, for example, the division of India, to say that it is done by the local people, everything is the fault of local people, according to certain school of thought, and outsiders have only given good to India. So I'm not in favor of changing everything, but you have to mix the Indian knowledge system and see that how we have understood the world, and then the reality of the present day time, and then go ahead. For example, recently I was reading a case where the Commercial Codes of Commercial Code Act 2015, it was in conflict with the CPC laws. And then if you read the Commercial Code Act 2015, it says that it categorizes disputes as commercial, and only if the dispute is commercial, then only you will go and file your cases before the consumer, before the commercial courts. I invited once a professor from Sanskrit University. She said that in old India, we had accordingly categorized the disputes, and there were tribunals for those disputes. So the thing is that at that time, the commercial activity may be limited. Today, the commercial activity has simply exploded. So you can't say that, okay, we want to apply exactly what was there. No. The thing is that they understood tribunalization and the need of the tribunal. You read, you at least teach that as an Indian legal history. We are teaching the colonial history in form of our books and calling that Indian constitutional history. For God's sake, that's not true. That's colonialism. For example, read, आप आज जाकर के केस पढ़िएगा सल्ला मुक्कर का, लास्ट 3 पेजेस पढ़ लीजिए. मैंने अपने बच्चों को दिया, जानबूझ के दिया वो केस मैंने. उसके लास्ट पेज में लिखा है कि सेक्युलरिज्म आया क्यों? क्योंकि जब जस्टिस, इक्विटी एंड गुड कंसाइंस अप्लाई करना था, बिकॉज ब्रिटिशर्स फाउंड देमसेल्व्स willy-nilly administering law, resolving disputes, so they did not know which law to apply on whom. This is exactly secularism. So William Bentinck decided that, okay, we will go by justice, equity, and good conscience. And what is the meaning of the justice, equity, good conscience? The laws of the England, because they were basically governed by the Admiralty law, which was the laws applicable on the ships. But the principles of justice, equity, and good conscience to be applied on the dispute, which they did not understand what laws were governing. It doesn't mean there was absence of the law. There was absence of the understanding of the law, absence of the understanding of the language. So in that case, they said, okay, we will go by the justice, equity, and good conscience. But what was the content of the justice, equity, and good conscience? Arbitrariness? No. So all I'm saying, I don't know, Khushbu, how much you understand me, perhaps, but I'm saying that I'm not in favor of saying everything needs to be changed. But yes, assimilation. Some good acts has come, some bad acts have come. So simply take that out, assimilate, take the good from, because for 1,000 years, the Britain is our history, part of our history. The Mughals are part of our history, but not the history the way it has been portrayed to us. The real history needs to be shown. And then we will have the reconciliation by simply ramming down the lies and the propaganda and saying that no, you are lying. This is all a phobia of the Abrahamic faith is the not right way to move forward. Then you will have Britain, you will have Germany, Europe is exploding. You will have Italy. Europe is exploding in flames because they also tried to do the same thing. Reconcile the different philosophies, not to find mistakes in certain philosophies. So I am proud that I speak English. I have no shame of it. Those English had done miserable things to India. As I told you, they attempted to make India a Christian state. Yes. Did I answer your question, Khushbu? I think I did, but I don't know whether you accept it or not.
Yes, sir, definitely. Thank you so much.
Sir, we will take now a last question from Veer Srivastav. He is asking regarding caste system which is prevailing in non-Hindu communities. And if I will take the crux of his question, that why everybody is not talking, everybody is very much perturbed about the caste system and untouchability in Hindu society. But with respect to non-Hindu societies, nobody talks about caste system which is prevailing there. Why it's so?
That's a good question. That's a very, very good question. See, that's what I'm saying. When Hindu becomes Christian and Hindu becomes Muslim, it's easy to say that you sever yourself from everything which was Bharatiya. Hindu is not the right word. Hindu, as I told you, is basically Gentu. It's the external aspect of Indian identity, not the internal aspect of Indian identity. So when I convert to Islam, let's say tomorrow I get extremely moved by the idea of the principles of Islam, I accept it. But I was a Brahmin. What will be the status of me who joined Muslim community, who are now claiming reservations because of being the religion, because being the part of a particular religion? अब मैं सारी जीवन मेरी जिंदगी में मैं ब्राह्मण था और मैंने अब आजकल तो पहले ब्राह्मण अगर जातिवाद करते थे, आज के डेट में नॉन ब्राह्मण जातिवाद है. So India has only the non-Brahmins have become, if the idea of Brahmanism is an evil idea, then what were non-Brahmins doing today was, if the claim that if the Brahmins were very brutal about the caste system, the same thing is being done today by those who are asserting their caste. They want to keep their caste. That's how the Indian justice system, when I say justice here, not the criminal justice or this thing, the social justice and economic justice. It gives you more incentives to be a casteist, belonging to a certain caste. So if your philosophy is that if you are backward and I'm going to incentivize it, then everyone is in the race of incentivizing. So now I'm a Brahmin, I also want to have that incentive. But what will I do? Because I'm a Brahmin, I cannot have that incentive of the social justice. I would convert to Islam and say that give Islam a religion, because according to social committees, Muslims are not having the fair share. So now what they have done, that there is an idea of some subaltern concept of some Marxist school of thought, that within the Islam also there is a Pasmanda Muslim, non-Pasmanda Muslim, and which is all nonsensical, by the way. Because even if you read the Quran, it says that the Muslims are of two categories, Arab and Ansar. Those who are non-Arabic, they were not the equal as the non-Arabic Muslim are not equivalent to the Arabic Muslim. You can go and read the books of the Sharia. So they are not equivalent to Arabic Muslim and non-Arabic Muslim. Even in the heaven, you will have a different strata of heaven determined by what is your ancestry of Islam. So the point is that the caste system is now being pitched in the Muslims to give them the benefit of Article 16, the reservation. But the idea of the reservation, or the rationale of the reservation embedded in Article 16, is the deprivation of the society, social justice to certain section of the people by the hierarchical order of Indian caste system. And Supreme Court has written lots about it. You can read many cases. But you have cases like Nagraj and all that, where the court also said that caste cannot be a class, because it's a concept between class and caste. Because the Article 16 mandate for a reservation is that a class can have a reservation, not a caste can have a reservation. The class can have a reservation. So the argument has been, can a caste be a class? For order to form a class, can caste be considered as a class? Or should there be many castes to form a class? What are the constitutive elements of creating the class as envisaged under Article 16? And the courts have said that it's the backward class, because 16 says that backward class of citizen, and the backwardness, the element of the backwardness in Article 16 and is the only backwardness of in the Supreme Court's decision is the social and educational backwardness. No other backwardness will be taken into consideration. So economic backwardness was completely denied by the Supreme Court to be considered as, because they said that Article 16's rationale is the caste deprivation, is the hierarchy of the caste. And therefore, if you are economically lagging, you are not in the scheme of Article 16's backwardness, because you have not suffered that persecution is perhaps a wrong word, that sufferings of being a person of a lower caste. And therefore, economic backwardness is not to be taken into consideration, because the idea behind is that those who have been kept outside the social justice should be brought back in the social justice in form of political empowerment by virtue of Article 16. So the caste system, the economic system was ruled out. Class was considered as social and educational backwardness. And then the class, now M. Nagraj said that caste cannot be class, but in Indra Sani they said caste can be a class. Though only caste can be a class is a wrong idea, but to say that a caste cannot form a class in Article 16 would not be a right interpretation of Article 16, and rightly argued and stated by the Supreme Court. I would also say that. But the question is that, can Muslim part a socially educationally backward class? Can you give them that benefit? The Supreme Court is saying that if they have suffered the social injustice, then only the benefits of Article 16 would be extended to them. But as a Muslim, they have never suffered the injustice, because they were the rulers of India. At least they claim it for 700 years. So the rationale of Article 16 and the grant of Muslims, as a Muslim, the reservation would be in clash. Although you can argue that, why can't a religion be a class under Article 16? I can argue Christians can be a class, Muslim can be a class, Buddhists can be a class, Parsis can be a class, Jews can be a class. Why not? What stops them? And then the backwardness, socially and educational backwardness, you can determine. But since this logic that the suffering is the basis of the advantage given to them now by the interpretation, they are saying that Muslims can't claim it that way. So now what's the scheme of those who are lawyers and understand it, that claim that the Muslims also practice the caste? And if you could establish it in the court of law that the Muslims also practice the caste, then the barrier of the argument of Article 16 that Muslims did not suffer would be included in form of pasmanda and other kind of backwardness in the Muslim, that the sufferings was there, though they did convert, but they still remain the part of that caste, and therefore the sufferings of the caste, of their equivalent caste to Hindus, should also be extended to the Muslims, because that essentially kept them outside the social justice of the Indian political system. So this is the new constitutional argument being framed, and I would say that's a very dangerous sign. As I told you, Constitution of India incentivizes to be minority, incentivized to be backward. So I want to be backward too. तो अब मुझे अगर रिजर्वेशन लेना है, तो लोगों ने किया, एक हिंदू लड़की थी, उसने जाके शेड्यूल कास्ट से शादी कर ली. अब क्वेश्चन हुआ कि क्या वो कैन शी क्लेम द बेनिफिट्स? सिमिलरली अगर मैं कल को मुसलमान बन जाऊं, मैं कि मैं देख रहा हूं कि भाई कोर्ट ने ये कह दिया कि अगर आप ब्राह्मण हो और आपने किसी लोअर कास्ट से शादी की है तो आपको बेनिफिट नहीं मिलेगा, सुप्रीम कोर्ट ने साफ साफ कह दिया, तो वो रास्ता तो बंद हो गया मेरे लिए कि मैं जाके किसी शूद्र लड़की से शादी कर लेता और मैं कहता मेरी बीवी शूद्र है तो मुझे भी शूद्र कर दो, या कोई ब्राह्मण लड़की है वो शूद्र से शादी कर लेती, कहती कि देखो मेरा पति शूद्र है, मैं भी शूद्र हो गई तो मुझे भी वो दे दो। सुप्रीम कोर्ट ने वो रास्ता बंद कर दिया इन एन नंबर ऑफ केसेस, कहा कि नहीं ये नहीं हो सकता, आपको वो बेनिफिट नहीं मिलेगा। तो अब मेरे लिए क्या रास्ता बचा? मेरे लिए रास्ता एक ये बचा एंट्री, मैं मुसलमान बन जाऊं और मैं कहूं कि भाई मैं पसमानदा मुसलमान हूं। अब ये सुप्रीम कोर्ट की इंटरप्रिटेशन पे आएगा कि क्या कास्ट का वो आप बैकवर्ड क्लास में, चूंकि क्लास में कास्ट ही होना चाहिए, अदरवाइज तो इस्लाम के नाम पे भी रिजर्वेशन दिया जा सकता है, बट कोर्ट उसको एक्सेप्ट नहीं करेगा क्योंकि वो कहेगा इसमें जो क्रिश्चियनिटी और इस्लाम है इनमें एटलीस्ट आर्ग्यूएबली, आई डोंट एग्री विद दैट, बट आर्ग्यूएबली देयर इज नो सफरिंग बिकॉज इफ यू आर अ क्रिश्चियन you are an equal to other Christian, if you are a Muslim you are an equal to the other Muslim. That's essentially not true, because if you're a Muslim woman then you are not at par with the Muslim men, if you are an Arab Muslim you are not at par with the non-Arab Muslim. So the essentially argument is not that true, but it is a what do you call a bypass that you can create and then claim it. So an attempt is being made for that. Let's say how courts accept this argument. I think the argument doesn't have a merit. Did I answer your question? I don't know if you I hope
yes, yes. Okay, now on behalf of all the participants, I convey my thanks to Abhishek sir for his valuable deliberations, insights on the topic. Thank you, sir. Thank you, Abhishek sir.
Thank you, sir. Thank you.
Thanks, everyone. Thanks, Abhik sir, Yashomati ma'am, and thanks all participants for sparing your valuable time. Thanks a lot.
Thank you. Shall we leave?
Yes, sir. Yes, sir.
Okay. Bye, everyone. Thanks for your patient sharing. I hope I